Hello everyone, today I'll be sharing you another legal story. So what happened on 19th August 2025 is the Supreme Court, while dealing with the matter of precedent reference, so a reference was made by the president in the month of May, that is 3 months back, to the Supreme Court under Article 143 of the Constitution. Article 143 basically talks about the power of the president to consult the Supreme Court, right? So the president, in exercise of its power under Article 143, asked the court that whether a timeline of 3 months can be set up for the president, right? So basically what happened is that under Article 201, the governor has the power to reserve the bill, right, for the consideration by the president, right? So if in case the governor reserves the bill, right, for the consideration by the president, can a timeline be set up for the president to make a decision, right, in this regard? So since there is no constitutionally prescribed timeline, okay, there is no constitutionally prescribed timeline, right? So the whole issue, this whole scenario started after the judgment by the division bench of Supreme Court, which fixed the limit of 3 months for the president to make a decision in case the governor reserves the bill for the president assent. So the division bench of the Supreme Court fixed a timeline of 3 months, and the president made a reference to the Supreme Court asking that whether a timeline of 3 months can be set up, since there is no constitutionally prescribed timeline. Okay, so the issue in this case scenario was basically, can the judiciary fix a time limit for the exercise of power by the president under Article 201 and the governor under Article 200? So under Article 200, what happened is basically, after the bill has been passed by both the houses, the bill is presented to the governor for his assent. Okay, so can a timeline be set up for the governor under Article 200 and for the president under Article 201, because there is no constitutionally prescribed timeline. Okay, the Solicitor General Tushar Mehta, basically he was representing the union government. While arguing, he referred the Constitutional Assembly debates, okay, and he submitted that Dr. B.R. Ambedkar brought an amendment to replace that not later than 6 weeks, that was introduced by Dr. B.N. Rao, with as soon as possible, right? So he brought an amendment to replace the not later than 6 weeks with as soon as possible, right? On this, the member of the assembly opposed the amendment, calling it as vague and meaningless, but ultimately the Ambedkar amendment was adopted, and this amendment you can see in the article 201, where as soon as possible is written. Okay, so Mr. Mehta also mentioned that the Constitutional Assembly consciously omitted the timelines for the president and governor, since the power is conferred to the highest executive, and he may not be bound to by such time limit of 6 weeks that was discussed by the Constituent Assembly. Okay, and we always follow a system that the highest constitutional functionary will function in accordance with law, right? To this, the CGI said that the member suggested that as soon as possible but not later than 6 weeks. Okay, the members of the Constituent Assembly suggested as soon as possible but not later than 6 weeks, and we can take debates of the Constituent Assembly into consideration while interpreting the constitutional provisions. Okay, so this was all happened on 19th August 2025. Now let's wait for the next hearing, right, to get further updates. Okay, thank you so much.